lords, my lady, good morning. I appear in this matter with my own friends, Mr. Brinsmead Stopper, Mr. Hellier for the appellant,
Yes.
Mr. Baldry, Mr. Chacker, Mr. Kirby appear for respondent. The parties have agreed a timetable between us, which I think was provided to the court.
Yes, I just wanted to mention a couple of things about the timetable. And this is a time of year when people are leaving and having valedictories, which is partly why we started late today. So I would propose that we sit until 4:30 today. And because we have to prepare for another valedictory tomorrow and put all our ceremonial kit on, I would suggest that we sit at 10 and rise at 4.
Well, I'm obliged. The court will have seen that the parties had agreed that I will address the matters where I'm the appellant, my friend will then address all of his matters in his respondent's notice, and then we'll deal with them by way of reply to the relevant issues.
Yeah, I can also tell you that we have completed the reading list that we were given.
I'm obliged. We're conscious that it was quite a reading list, but we're grateful. So I propose to address the court under 4 headings. Firstly, some observations by way of introduction. Secondly, I'm going to address issue 1B and the meaning of the relevant charging provisions for corporation tax purposes. Then thirdly, to address issue 1A and the relevant principles of partnership law. And then fourthly, to address issue 5, which is the question of whether the loan relationship here is for the purposes of a trade. So with that structure in mind, by way of introduction, the court will have seen that this appeal essentially falls into 2 parts. There's a question about the taxation of profits and a question about relief for the payment of interest. Both issues arise out of transactions whereby sums were borrowed to acquire a 19% share in a UK partnership carrying on an investment management business in London. That investment manager is BlueCrest, providing investment management services to funds made up of third-party investors and to third-party investors themselves. That business was conducted at the start of these events by a UK limited partnership formed under the Limited Partnership Act 1907. That business later came to be conducted by a limited liability partnership. The 2 original founders of the BlueCrest business were Mr. Platt and Mr. Reeves. Later, a subsidiary in the Mann Group came to hold a 25% stake in the business, and that was a company called Sugar Key. Mr. Reeves decided to step back from the business and was looking to sell some or all of his share in it. BlueCrest wanted to find a way to acquire that stake in a manner akin to a management buyout, so that what Mr. Reeves sold would be available as a pool of so-called equity to attract and retain talent in the future. Mr. Platt and Sugar Key also decided that they would reduce their stakes in the business such that in the event there was a 19% stake in the UK investment management business to be sold and acquired. Putting that transaction together involves solving 2 problems. Firstly, how to finance the acquisition, and secondly, what entity would be used to purchase and hold the 19% stake. In the event, the Royal Bank of Scotland, RBS, agreed to lend most of the purchase price, with the balance being lent by the 3 vendors, Mr. Platt, Mr. Reeves and Sugar Key. As to the relevant entity, BlueCrest decided to set up a Cayman entity to hold the stake, Cayman being chosen as a suitable venue for regulatory reasons. That entity was an exempt limited partnership under Cayman law, which we have referred to in our skeleton, and I will for the purpose of this appeal, as Cayman LP.
What is it exempt from? Some Cayman regulation? Or?
Yes.
Yes.
There are both limited partnerships in Cayman and exempt limited partnerships, and the regulatory regime is slightly different.
Exempt from what?
I confess I can't tell you off the top of my head, but we will check. I do know it's a different regulatory regime. Now, the general partner of that Cayman LP is is a company which I'll refer to as Cayman Limited, it borrowed the money to acquire the 19% interest in the UK LP, and it became, albeit briefly, a member, a partner in the UK LP. Cayman Limited then contributed the 19% interest in UK LP to the Cayman LP on terms that, perhaps put this in quotes, but Cayman LP would become a member of the UK LP, and once that was done, Cayman Limited resigned as a partner in UK LP. Now, under the UK LP deed that was executed to give effect to those steps in 2007, the partner in UK LP is described as the Cayman LP. However, under Cayman law, a Cayman limited partnership does not have separate legal personality. RBS also became a member of Cayman LP with an entitlement to profits under the Cayman LP deed in two circumstances. Firstly, if there was what was called a trigger event, the main one being if the assets under management by UK LP fell below a certain level, then RBS had an entitlement to profits under the Cayman LP deed that were derived from the UK LP. Now, that's a feature we're not concerned with because in the relevant periods there was no trigger event. The second circumstance in which RBS would have an entitlement to profits under the Cayman LP deed was if the UK LP made what were called super profits, i.e. profits in excess of a benchmark. And we are concerned with super profits because in a couple of years super profits were made. Now, RBS agreed that if it received a share of Cayman LP profits representing super profits from the UK LP, it would make a payment under a total return swap, which it had entered into with the parent of Cayman Limited, a company we refer to as Cayman Holdings. Cayman Holdings in turn agreed to use such sums to subscribe for shares in Cayman Limited, and Cayman Limited would then be in funds to repay elements of the loan to RBS. And all of that was put in place in 2007. In 2008, RBS decided that it didn't want to be a partner in Cayman LP anymore. It remained as lender, but it gave up its membership as partners' interest in Cayman LP, and that interest was taken over by a company in the Morgan Stanley group called Filed.
Filed, that's how you pronounce it, is it?
Yes. Filed Energy Limited, but yes, F-Y-L-E-D. The total return swap was also later replaced by a financial contract entered into between Cayman Holdings and a different company in the Morgan Stanley group, that company being MS Cooper. Now, so that the court has the timeline in mind, there was one allocation of super profits in a period when the UK business was carried on by the limited partnership, and Filed was a partner in Cayman LP, and the total return swap was in place. There were then later allocations of super profits in the following year, in a period when the UK business was carried on by the LLP, and in respect of one of those, Filed made a payment under the total return swap, and in relation to the other, MS Cooper made a payment under the financial contract. whether there's a relevant difference in all of that, we'll come back and address in due course. For tax purposes in the UK Limited Partnership and the UK LLP are treated as what is known in the jargon as transparent. You look through the partnership and tax the partners on their appropriate share of the profits of the underlying activity. And if they're individuals, they pay income tax. And if they're companies, they pay corporation tax. Cayman LP is also treated as transparent for UK tax purposes. Now that's pursuant to the revenues policy. The court may have had cause at some stage to look at this, but they list in their manuals all the foreign entities they've come across, and they badge them either as transparent for UK purposes or opaque. Cayman Limited Partnerships are badged as transparent. So you look through Cayman Limited Partnership in the same way as you would UK Limited Partnership.
And HMRC have some sort of statutory power to do this, do they?
It's part of their care and management. So they take a view as to whether with a foreign entity, put simplistically, you either look at it or you look through it.
And that's a what? Power and Taxes Management Act? Is that where it comes from?
Yes. Now here we're concerned with a UK investment management business. So what we're concerned with are trading profits, and those profits are liable to UK tax. So there is no issue between the parties that these profits are liable to UK tax. The principal issue is which party is liable to tax on the profits. The revenues case is that Cayman Limited is taxable on the 19% of profits that are derived from the UK LP to the extent that those profits are allocated under the partnership deed to FILED as super profits. So the deed provides for the allocation of the profits to FILED, but the revenues say Cayman Limited is taxable on those profits. We say, no, that's not right, FILED is taxable on those profits. And that's what gives right...
In the relevant years, are the only contenders Cayman Limited and FILED?
As regards super profits, yes. Ordinary profits are dealt with elsewhere.
But we're not concerned with that.
And we're not concerned with that. There is no issue between the parties as to their taxation.
Thank you.
So in the relevant year, the two contenders are Cayman Limited or FILED. Now, issue 1A is whether, as a matter of law, or at least as a matter of the agreements that the parties entered into, FILED becomes a partner in UK LP. There's a nice question there of partnership law, which I'll come back to in a moment, a little while. Issue 1B is assuming that Cayman Limited is the only partner that is the only entity that is a partner in UK LP relevantly. We say that Cayman Limited is not taxable and FILED is, because Cayman Limited is allocated the profits that represent the super profits in UK LP in a fiduciary or representative capacity, and that means it is not taxable, but FILED is. Now, if we're right about either of those issues, the revenues say, applying some Ramsey-derived interpretation of the relevant statute, that because of the total return swap and or the financial contract and the subscription deed, Cayman Limited is taxable on those profits in any event, and FILED is not. And that's issue 2. So those are the profits taxation questions. The interest relief question is simpler. It is now common ground that Cayman Limited can get interest relief on the sums that it borrowed pursuant to what's known as the loan relationship regime. The only debate in this court is whether it gets relief under the Loan Relationship Code for what is called a trading debit, or instead as a non-trading deficit. And the former is more useful to the BlueCrest group. We say it gets relief as a trading debit, but that question turns on whether Cayman Limited was a party to the relevant loan relationship for the purposes of a trade. We say yes, the revenue say no, that's issue 5. So with those observations by way of introduction, I propose to address issue 1B before 1A.
Yeah.
So turning to...
I should have asked Mr. Peacock, I am assuming that we will get daily transcripts of the appeal. Is that correct?
That is correct. They may well be rolling up on a screen in front of you, but whether they are or not, you will get daily transcripts.
It's not rolling up because one needs to log in, and I don't know how to log in. It's a fairly basic technical question. I would quite like, if it's possible, for it to roll up so I can see what you've just said as well as listen to it. But if that could be arranged at some stage.
Well, we will endeavour to arrange it so that it at least is working by this afternoon.
I think you log in by entering your email address.
I've tried putting my email in, but it also wants a password. And I've no idea what my password might be.
I have no idea what your password is. I also have an account and I can't remember my own password. But we will endeavour to fix that by this afternoon.
Thank you very much.
So turning to issue 1B, the relevant question here is whether Cayman Limited can be charged to tax on the super profits made by UK LP, which are allocated under the deed to Fiduciary. Now, for present purposes, I'm going to assume that you're against me on issue 1A.
So we assume for this purpose that of the members of the Cayman LP, only Cayman Limited is a partner in the UK LP.
Yes.
That's the assumption.
That's the assumption. I'm going to say in a little while that's not right, but for present
Yes.
purposes, I invite you to assume that. Now, the current position in relation to issue 1B is this, that the first tier did not address the issue. It was a live issue in the appeal. It was argued in front of the FTT, but they didn't address it in the decision. And that was found to be an error of law by the Upper Tribunal, which did address the issue, and the Upper Tribunal determined that the relevant provisions, so Section 8 of the Income Corporation Taxes Act 1988, and relevantly Section 6 of the Corporation Tax Act 2009, the Upper Tribunal held that those provisions did not apply in this particular case, the Upper Tribunal adopting a particular construction of the provisions to arrive at that conclusion. We set out in our appeal skeleton a detailed critique of the Upper Tribunal's reasoning in that regard, and my learned friend's skeleton makes no substantive attempt to defend the reasoning of the Upper Tribunal. Instead, what the Commissioners now seek to do is to uphold the result arrived at by the Upper Tribunal on the basis of a number of arguments that are set out in my learned friend's skeleton from paragraphs 50 through to 72, which I will address in due course.
On the fiduciary relationship point, that's the focus.
Yes, my learned friend has 5 arguments. 4 I'm going to badge as subsidiary arguments. His main one is, well, even if you're right about the interpretation of the statute, Cayman Limited doesn't get these profits in a fiduciary capacity. And we say he's wrong about that. But just pausing there before I come to the detail, if one stands back for a moment, what my learned friend is saying is that if one partnership apparently becomes a member of another partnership, but the right analysis is that it's only the general partner of the, call it the top partnership, that becomes a member of the bottom partnership, profits that are allocated to that general partner are only taxable in the general partner, and the entitlement to the profits of the other partners, here any other limited partner with an entitlement, that is in effect an entitlement to free money. Because you get your partnership share without a tax liability, because all of the tax liability is said to fall on the general partner. And that is an odd state of affairs, to put it at its lowest, which we say is not right as a matter of principle, but not actually right as a matter of statutory construction.
Can I mean, this may not be of any relevance at all, but when you're taxing an ordinary UK partnership, an 1894 Act partnership, it's transparent. So the liability is that of the partners, according to how the profits are split up under the partnership deed. But is it not the case that it's a debt that's then the debt of the firm, which is a joint and several liability of all the partners in the firm? Or am I wrong about that?
The way it works, I'm going to show you the relevant statutory provisions and some judicial commentary on it, is you compute the profits in a certain way. You then allocate the profits according to the deed to the relevant partners, and then it is the partner's liability to account for their tax.
So you don't have an assessment on the firm? No. No. Okay. Thank you.
So our case in outline, I'll show you the relevant provisions in a moment, is its common ground, and assuming we're wrong on issue 1A, that Cayman Limited was allocated a share of the profits of UK LP in its capacity as the general partner of Cayman LP. We say the relevant question then, applying the proper construction of section 8, is whether those profits were allocated to it in a fiduciary or representative capacity. And if it is, then the general partner here, Cayman Limited, would only be liable to corporation tax in the UK to the extent of its beneficial interest in those profits, if any, and where it has no beneficial interest in those profits, and they are instead profits to which other partners are beneficially entitled, then it is those other partners that have the liability to corporation tax. Now, the first tier had the benefit of some expert evidence as to Cayman law. So each of the parties procured some expert evidence from a Cayman lawyer. There was then a joint report produced.
Which I don't think we have, do we?
You have extracts from
the individual reports. I don't think we have the joint report.
No, it's a relatively long document, and that was one of the documents that was left out of the bundles when we cut them down. But we can certainly make available copies if it would be useful. But the first tier concluded on the basis of that evidence as to Cayman law that the profits that were allocated to Cayman Limited were allocated to it as the general partner, and that's a proper reading of the relevant deeds. And that's summarised in paragraph 135, in particular subparagraph 4 of the first tier's decision. And there's no challenge to that basic fact.
Yes, I don't know whether it may or may not be relevant in view of some of the arguments that HMRC are advancing, but the Cayman experts agreed that the general partner holds property on trust for the partnership as opposed to profits. May or may not matter.
I'm going to say, well, once you see what else the first tier found, there's no relevant significance in that, but your logical information is right. I can come back and deal with that just in a little while. At this stage, I was going to offer to show the court the relevant allocation provisions of the deeds. I'm content to do that. If the court tells me, no, you've looked at those, you don't need that help, then I'll move on. But it may be useful for you to see in outline, at least, how the allocations work.
Let's see it.
Well, we need to start with the UK LP deed, and that's in Supplementary Bundle A. Tab 2, and in particular it's clause 12, which is at page 28 of the bundle. So the deed makes separate provision for allocations and distributions. It's clause 12 that deals with allocation. And 12.1 has relevantly 3 parts labelled capital A, capital B and capital C. 12.1 capital A, one could mark in the margin, this is ordinary profit allocation. This is in a non-super profit world. We're not directly concerned with capital A. But because super profits refers back, if you look, there's a hierarchy provided for in 12.1 capital A by reference to numbered paragraph 1. The first allocation is to the general partner to meet working capital. That's 3 lines up from the end of the page. General partner for working capital. Over the page 2, second allocation is in the discretion of the general partner, not exceeding the performance fees received by the partnership. And that's to recognise investment performance. And then third allocation in paragraph 3, allocated to the special limited partner, and the special limited partner is defined as the Cayman LP. If one goes back to its numbered party 54 on page 20, the special limited partner is the Cayman LP. So the third allocation is to the Cayman Partnership, equal to aggregate advance drawings, and those are defined later in clause 13 as being sums equal to the interest that is due to the Royal Bank of Scotland on the bank loan. And then the fourth allocation under capital A, the remainder, is in accordance with the agreed proportions, and those are the proportions that are identified in letters of allocation given to each of the partners. So bear that in mind. Then capital B deals with the profits of the then current financial year ending November 2007, so we're not concerned with that. And then over the page at page 30, these are a special allocation so the provisions of 12.1A4 shall cease to apply, and the remaining profit shall be allocated to the special limited partner during any facility trigger period or any notary payment period. So if there's a trigger event, then the bank has a priority slice of profits.
So this overrides the limited partner's entitlement.
Yes.
Yes.
And then we're not directly concerned with D&D. So that's an allocation from the UK LP up to the Cayman LP in certain circumstances. If we then look at the Cayman LP deed, which is the same volume behind tab 3, page 66 of the bundle, that has a similar allocation clause in 12.1, which begins at page 76. And again, 12.1 capital A is the ordinary allocation waterfall, and that in order is 1, working capital, 2, sums equal to aggregate advance drawings, 3, aggregate interest payable on the notes being the borrowings from the vendors. And then over the page, top of page 77, fourthly, sums needed to redeem the notes, and then fifthly, in accordance with agreed proportions. And then capital B deals with what happens if there's a trigger event. And then it's over the page 78, capital C, that deals with the world in which there are super profits. So, paraphrasing, if the profits of the UK LP in a particular period that runs from 07 through to 2011, and reading about 7 lines down, if those profits exceed benchmark profits, then no profit shall be allocated in accordance with clauses 12.1A4 or 5 until an amount of profit of the partnership for the financial year equal to 19% of the profits of UK LP in excess of the benchmark, then defined as super profits, has been allocated to the corporate limited partner. And the corporate limited partner in this deed is the Royal Bank of Scotland. So the way these clauses work is that Cayman LP, I'm not begging any question as to what that means, but Cayman LP has a 19% interest in the profits of UK LP. Under ordinary profit allocations, that's dealt with under 12.1A or 12.1B. If there's a super profit made by UK LP, then the bank, as the corporate limited partner, has a priority profit entitlement equal to 19% of the super profit. So as regards super profits made by UK LP, the bank as corporate partner in Cayman LP gets all of the 19% that is allocated up to the Cayman LP.
But only if it's still a partner and if the TRS is still in force.
Yes. So if one thinks of a simple example of ordinary profits, where you've got 100 made by UK LP, 19 comes up to Cayman LP, and then that's shared in accordance with the Cayman LPD, but the bank gets nothing for that. If you've got super profits, let's assume 200 where the benchmark is 100, you've got 100 of super profits, 38 comes up to Cayman LP, and then 19 of that 38, being 19% of the super profit, goes to the bank. And this encapsulates the divide between the parties, because if I'm wrong on issue 1A, in English law, the only partner in UK LP relevantly is Cayman Limited. It receives as the general partner the partnership deed in Cayman allocates those profits to RBS or later FILED. The revenue say Cayman Limited is taxable on them, and filed is not. We say, no, once you've read and given effect to the deed and to the relevant statutory provisions, it is filed that is taxable on those profits, and Cayman Limited is not. Now,
Has HMRC sought to recover any tax from Filet? Has there been any assessment? We don't know.
we don't know. We don't know anything about the position of the Morgan Stanley Group. There was no evidence about that before the first tier. Well, only friend may know, but we don't.
It's irrelevant to your position.
But it's irrelevant. Now, turning then to what the First Tier Tribunal had to say about this. This is in the First Tier Tribunal, paragraph 135, and that's in the core bundle.
Page 308.
Tab 11.
Page 308.
308, I would like to. So this was the findings of the first tier, strictly as matters of fact, because it's foreign law. So they record in 1351 that there's no separate legal personality of the exempt limited partnership in Cayman. Not the looking at 3, the partnership can't own the assets because it has no separate legal personality. 135 sub 4, Cayman Limited as general partner holds the assets on trust for the partnership in accordance with the terms of the applicable partnership agreement, and that is also pursuant to section 6.2, later amended to 7.8 of the relevant Cayman statute. Sub 7, it's the Cayman Partnership deeds which set out the contractual rights of Cayman Limited and the limited partners in Cayman LP to share in the profits of Cayman LP. And then 8, they fall to be allocated in accordance with clause 12. And then they mention the total return sought from the financial contract. And then 136, accordingly, as the experts agree, as a matter of Cayman Islands law, the profit-sharing agreements were confined to the Cayman LP deed, under which Cayman Limited's entitlement to profits of Cayman LP did not include those allocated to RBS and subsequently Filet. So it was found as a fact that Cayman Limited had no entitlement to the profits that were allocated relevantly to Filet. And with that in mind, can I then invite the court to take up the relevant statutory provisions in the first volume of authorities at tab 7, and in particular it's pages 63 to 65 of the bundle. There are relevantly 2 periods here. A period in which it was the 1988 Act that was in force, and there's a period in which it was the 2009 Corporation Tax. So tab 7, page 63, you see the charge of corporation tax under the 1988 Act. And that's 6.1, corporation tax should be charged on the profits of companies. And then 6.2, provision I'll come to in just a moment, but that provides that the provisions of the Income Tax Act relating to the charge of income tax shall not apply to the income of a company if the company is resident in the UK, or, my paraphrase, if the company has a permanent establishment in the UK. So if you've got a chargeable footprint in the UK as a company, you pay corporation tax, not income tax.
Well, what about the not arising to it in a fiduciary or representative capacity? Which seems to dovetail with Section 8, doesn't it?
Yes.
I mean, you would expect them to fit together.
Yes, and for a reason I'll come to in a moment, we say they do. But then turning to Section 8, so 8.1 is a general rule that a company is chargeable to corporation tax on all its profits wherever arising, subject to exceptions. And then the relevant provision for today's purposes is 8.2. Now, I'm going to come to the construction of 8.2 in just a second, but so that you can see what happens, the Income and Corporation Taxes Act 1988 was rewritten to the Corporation Tax Act as part of the tax law rewrite, not intended to change the law unless a change was identified. No relevant change identified, so they're designed to be the same. So the relevant provisions in the bundle are at behind tab 13, and the equivalent to section 8 is sections 6 and 7, page 107. Now, for present purposes, I'm going to concentrate on section 8 of the 88 Act, but there is designed to be no difference between the two acts.
Yeah.
So coming back to section 8, page 65, we say, properly construed, it breaks into two parts at the semicolon being in the third line. The first part, the company shall be chargeable to corporation tax on profits accruing for its benefit under any trust or arising under any partnership, in any case in which it would be so chargeable if the profits accrued to it directly. That is dealing with circumstances in which it might be said you had an indirect entitlement to profits, either through a trust or through a partnership, and that rule before the semicolon is designed to say you are still chargeable to tax on those profits received in such an indirect way, where you would be liable to tax on those profits had you received them directly. It's a rule that expands the scope of corporation tax. The second part, after the semicolon, says a company shall be chargeable to corporation tax on profits arising in the winding up of a company, but shall not otherwise be chargeable to corporation tax on profits accruing to it in a fiduciary or representative capacity, except as respects its own beneficial interest, if any, in those profits. And that is doing two things. It's telling us that a company is liable to corporation tax on profits arising to it on the winding up of a company, and if I interpolate, notwithstanding that it might arise to it in some fiduciary or representative capacity. And that provision was introduced in the Finance Act 1965, so right at the beginning of corporation tax, to deal with a decision of the High Court in a case called Olive Mill Limited in 1963. And in Olive Mill, there was a debate as to whether the company in the winding up, the company being wound up, was liable to profits, where those profits post the commencement of the winding up might arise to it in some kind of fiduciary capacity. This rule was introduced in 1965 to make clear that yes, you are still liable to corporation tax in those circumstances, even if those profits in the winding up might be said to arise to you in a fiduciary capacity. So that's dealing with the decision in Olive Mill. Olive Mill's in the bundle, tab 1, bundle 1, tab 30. But the second part of the second limb tells us that apart from that circumstance of the winding up of a company, company is not otherwise chargeable to corporation tax on profits that accrue to it in a fiduciary or representative capacity, save to the extent of its own beneficial interest. So the two parts of section 8 subsection 2 are doing different things. The first part is expanding the scope of corporation tax a little. The second part, in part, is making clear that a company can be taxable on profits received during the course of a winding up. But it is in the second part, laying down a general rule that a company is not liable to corporation tax in respect of profits to which it is entitled in a fiduciary or representative capacity.
Do you say that's the link with section 6?
Yes. So the way that it works is that you're not, if as a corporate, a company, you receive profits in a fiduciary capacity, you're not liable to corporation tax. You can be liable to income tax, but you're not necessarily liable to income tax because that depends on the application of the income tax rules. But for present purposes, we're not concerned with income tax. This is not an assessment to income tax on Cayman. It's an assessment only to corporation tax. And the general rule in section 8, subsection 2, second part, is that you are not liable to corporation tax on profits you get as a fiduciary.
So, although there may be an income tax liability, that's not the assessment. And if the assessment to corporation tax is wrong, then that's the end of it, is it?
Yes. And just so the court can see a little into the hinterland, the way the income tax provisions work depends on whether you're a bare trustee or not.
And if you are, it's another case of transparency. It goes through to the beneficiary.
Correct.
Yes. But if you're a discretionary trustee, you get taxed qua trustee.
Correct.
Yes. And that applies even if you're a corporate trustee.
That's, yeah. So a family trust, a discretionary family trust that happens to have a corporate trustee, the directors of that corporate trustee have to ask themselves when we receive income, are we in effect a discretionary trust, in which case the liability is ours, or are we a bare trust, in which case the liability is the beneficiaries?
Those are not exclusive.
They're not.
You can have fixed interest trusts that aren't bare trusts.
My lord, yes.
And then it depends on the nature of your entitlement.
Correct.
Yes.
And there's a whole swathe, as the court will expect, there's a whole swathe of income tax rules that addresses all of those potential categories. But Cayman Limited has not been assessed to income tax.
So does it come down to this? Is Cayman Limited the trustee of the profits?
My own friend's got some other arguments, which I'm going to run through quickly, which I say are wrong, but his main stance now is tacitly to accept the Upper Tribunal got the construction of 8.2 wrong, but to say, well, you don't get them in a fiduciary capacity. Now, I still need to address then two things. The first is, where did the Upper Tribunal go wrong? And secondly, what does the revenue now say about the operation of these provisions? Now, I think I can take the first part fairly quickly, because we've addressed this in our skeleton argument at some length. But what the Upper Tribunal did, and this is the Upper Tribunal's paragraphs 67 through to 98, the core bundle of tab 7, they identify rightly that the First Tier didn't address this, and it was wrong in law to do so, failed to do so. The Upper Tribunal then sets out the legislation, they're 71 to 76. They set out the appellant's case, that's 77 to 79. They identify the relevant findings of Cayman law, and that's 80 to 82. And then their reasoning begins at paragraph 83. tab 7,
Yeah, page 174.
page 174, right, law. Paragraph 83 onwards. They start by saying, well, partners are liable to corporation tax on the share of the profits that are allocated to them under the relevant partnership deed. And that is right. And they make the point that partners are taxed by reference to allocation and not receipt. And they're right about that. And they then make the third point, which is paragraph 84, that the allocation of profits by references to shares provided for in the partnership deed is not necessarily the same as the manner and the proportions in which the partners are liable to the debts of a partnership. And they cite Reed and Young, decision of the House of Lords. And they're right about that. So the best example one can think of is a farming partnership for an extended family, where grandparents may have 20% of the assets and the liabilities, but only 10% of the profits. They put the land in, and children and grandchildren might put cash or labour in. So there's no necessary requirement that your share of assets is the same as your share of profits. That's a matter for the partners to agree. And the point that's made in Reed and Young by Lord Oliver is that there is a conceptual difference between an entitlement to a share of profits and an entitlement to assets or an obligation to meet liabilities. And we accept that entirely. But what the Upper Tribunal then do in their paragraph 85 is to say, 6 lines down, by parity of reasoning, to Reed and Young, it's irrelevant to consider whether the profits of a partnership have been distributed to the individual partners, and if so, what amounts they've actually received. This is because the profits or losses of a partnership are conceptually distinct from its assets and liabilities. Well, in one sense, that's true, but it doesn't tell us anything relevant to the answer, anything relevant by way of answer to the particular statutory question that we're here concerned with. So Reed and Young is a red herring with respect. So what matters here, we say, is that Cayman Limited was found not to be entitled to the profits that were allocated under the Cayman deed to Phyled. And that's paragraphs 135 and 136 in the first tier. And if the Upper Tribunal are doubting or questioning that in their paragraph 86, then they were wrong to do so. They failed to give proper effect to the first tier's decision. And then their paragraphs 87 through 88 and 89 make the point that the allocation of profits is different to the withdrawal of cash. Again, we say they're right about that, but not relevant to these questions. But then significantly, we say they get the construction of section 8.2 wrong from paragraph 90 through, it's 90 through to 93 on section 8, and they then do the same exercise on section 6 of the Corporation Tax Act, paragraphs 94 through to 95, and then apply their conclusions in 97 and 98. And we say with respect to the Upper Tribunal, that's what they've got wrong. They've misunderstood the way in which section 8 works. And we set that out in our appeal skeleton, paragraphs 46 to 48. Now, I'll come back and deal with the detail of that if need be, perhaps in reply, but for present purposes, we've set out our critique of where the Upper Tribunal went wrong. and there's no relevant difference in their reasoning as regards Section 8 compared to Section 6. So they've misunderstood the relevant provisions. Tacitly perhaps recognising that, the Commissioner's skeleton argument in this appeal contains one main argument and four subsidiary arguments as to why the relevant provisions do not apply in the way that we have identified. I'll just enumerate them before dealing with them. But their main argument is that the profits of UK LP do not accrue to Cayman Limited in a fiduciary or representative capacity. Their subsidiary arguments are two, that our case would lead to the corporate partners being liable to income tax. That's one of my friends, paragraphs 52 to 55. Or three, that our case seeks to tax the limited partners in Cayman LP as if they were beneficiaries under a trust. That's one of my friends, paragraphs 59 to 67. Or four, partners are liable to UK tax on a notional amount, being the amount calculated in accordance with the partnership provisions, and that's not property which can be held on trust. That's what my friends, paragraphs 69 to 71. And then fifthly, in a sense, all partners in Cayman LP have a beneficial interest in the income of Cayman LP, so that even if the relevant provisions applied in the way that we say they do, the income would still be within the charge to corporation tax in Cayman Limited, because Cayman Limited, like its fellow partners, is entitled to all of the income of Cayman LP. And that's a point that's raised likely in Mullen and Friends paragraph 72b. I can deal, I hope, quickly with the subsidiary arguments in turn. The second one was that our case would lead to the corporate partners being liable to income tax. And that's not the effect of our case. We are not contending that corporate partners generally, or Cayman Limited specifically, is liable to income tax. The way these provisions work, reading Section 6 and 8 of the 1988 Act together, is that UK resident companies or non-resident companies with a permanent establishment in the UK are liable to corporation tax. Non-resident companies can be liable to income tax in the UK, can be but not necessarily will be. And a company that might otherwise be liable to corporation tax is not so liable and can be liable to income tax instead, can not will, where it is entitled to income in a fiduciary capacity. And one example of that is the point I discussed with my lord, which is a corporate trustee. You have to ask in what capacity is that corporate trustee holding the income. Now, our case is simply that the relevant provisions here entail that Cayman Limited is not liable to corporation tax on the profits derived from the UK LP, where it holds those profits pursuant to the Cayman deed or filet. So it seems to be common ground, in particular from my own friend's paragraph 54 in his skeleton, that if Cayman Limited is a fiduciary, no corporation tax is due.
Sorry, say that again.
It appears to be common ground from Malone and Friends paragraph 54 of his skeleton that if Cayman Limited is a fiduciary, no corporation tax is due. So we are not contending result that would upset the relationship designed in Section 6 and 8 of the 1988 Act to draw an appropriate distinction between persons liable to income tax and persons liable to corporation tax. We are not purporting or attempting to subvert that divide at all.
And I suppose you also say you're not saying that this income is tax-free, it's just that they've got the wrong person.
Correct. Think of a partnership. Top partnerships made up of A, B, C, D, and E. A is the general partner. That top partnership, I beg a question, but is a partner in the bottom partnership. Profits of the bottom partnership that are allocated to the GP of the top partnership. Let's assume it's 100 and they've got a fifth each. GP is taxable on 20. B, C, D, and E are taxable on 20. That's the right answer as a matter of principle. What you can't do is tax the GP on 100 and say that B, C, D, and E get free money. It's not the way the system works. So the contention that somehow we're subverting the divide between companies liable to income tax and companies liable to corporation tax is not right. The third subsidiary argument, or the third argument of subsidiary, is that we are attempting somehow to tax the limited partners in Cayman LP as if they were beneficiaries under a trust. We say not so. The relevant statutory provisions simply ask whether you have an entitlement to profits in a fiduciary or a representative capacity. It's not asking a question about trust or trustee or beneficiary. We're not here seeking to impose a trust law analysis on the taxation of partnerships. There's a danger in all aphorisms, but trustees are fiduciaries, but not all fiduciaries are trustees. We do not have to say that this court needs to analyse these provisions in terms of trusteeship. The only relevant statutory question is fiduciary. Nor is our argument one that rests on an allegation or a contention that the partners in Cayman LP have some kind of beneficial entitlement to profit or to a slice of profit. The only relevant question for this court is whether Cayman Limited is allocated profits under the deed in a fiduciary capacity. And there is something odd about the Commissioner's case here, because what they want to do is to respect the allocation provisions in the UK LP deed to follow a slice of profit from UK LP to Cayman LP. So they say that's effective as a matter of partnership law and respected as a matter of UK tax. But when you get to Cayman LP, they want to ignore the Cayman LP partnership deed, notwithstanding its effect in law, to facilitate the conclusion that it's Cayman Limited only that is taxable. So you are applying the transparency approach to UK LP and looking to the deed, but when you get to Cayman LP, you're apparently not allowed to do that anymore. And that is a significant principle flaw in the Commissioner's position. In that regard, and just because it fits in this part of the Commissioner's skeleton argument, the Commissioners say that profit is an accounting measure and not an asset that can be owned. they cite the judgment of Mr. Justice Mann in the Upper Tribunal in Anson at paragraph 38. My own friend's going to make a lot of this. I'll come back and deal with this in reply. But you need to read what Lord Reed had to say in the Supreme Court in Anson about the analysis of the Upper Tribunal. And it's fair to say that the judge's analysis in Anson was the subject of some fairly serious criticism in the Supreme Court, and is not a reliable guide, either in Anson or in this case. So in due course, if we need to come back to it, it's Lord Reed at paragraphs 35 to 40, and that's in the second volume of Authorities, tab 51, pages 622 and 623. So the attempt to portray our case as resting on some trust.
I mean, the statute expressly envisages that profit may accrue in a fiduciary capacity, whether it's properly so called or not.
Yes.
It may be an accounting measure, but the statute assumes that whatever the accounting measure produces is capable of accruing in a fiduciary capacity.
My Lord, yes. Section 8, a point I haven't yet made, but I was just about to turn to it. Section 8 addresses the position of a trust in 8.2. So you might get profits, I paraphrase, indirectly through a trust. Draftsman is dealing there with trusts. But after the semicolon, still in the same subsection, draftsman deals with fiduciaries, thereby making clear that that reference to profits in a fiduciary capacity is not limited to a debate about whether they're received as a trustee. And my Lord's observation deals with the next of the subsidiary arguments. This was a proposition where tax partners are liable to tax on a notional amount that's computed in a certain way, and that's not property you can hold on trust. We say that rather misses the point and the force of subsection 8, subsection 2, which is asking a relevantly different question, which is, are these profits allocated to you in a fiduciary capacity? We say that, again, misses the point. And then the last subsidiary argument is the contention that's faintly mentioned in Malone Friends paragraph 72b. And this is the notion that, well, in one sense, all partners have an interest in all partnership assets. So the argument seems to be, well, all partners have an interest in all of the income of the LP, therefore there's no real difficulty in taxing one of them on all of the income, even if you don't tax the others on any of the income. And we say that falls down for two reasons. Firstly, on the facts of this case, bearing in mind the position under Cayman law, the first tier found as a fact in paragraph 136 that Cayman's entitlement to profits of the UK LP did not include those allocated to RLPS and subsequently filed it. So that cuts that argument off at the knees. But in any event, all it leads, as we understand the logic, is a debate as to whether Cayman Limited is receiving these profits allocated to it as a fiduciary. So we don't see anything in Malone Friends' subsidiary arguments, as we've termed them. His only real point in defending the result of the Upper Tribunal, although it's not its reasoning, is the contention that Cayman Limited here did not become entitled to the share of the profits of UK LP in a fiduciary or representative capacity. And we say that is answered by the findings of fact made in the first tier as to Cayman law. One needs to read paragraphs 135 sub 4 and 136. And if one wanted any further support for that, one can see also in the Cayman LP deed which is in supplementary bundle B. First bundle B, tab 10. This is the same as in the core. I've got the B bundle reference. Tab 10, page 152. Clause 18.4. That is an express agreement that the general partner of the Cayman LP has fiduciary responsibility for the safekeeping of all of the funds and assets of the partnership, etc. So by contract between the parties, it is given a fiduciary role.
Can you do that? You create fiduciary obligations expressly by contract? They are imposed by equity depending on other terms of the contract. If you weren't otherwise, I mean, could you say, agree with your bank, for instance, that they have fiduciary relationship? They have fiduciary duties, even though there's an ordinary banker-customer relationship? Debtor-creditor?
In that circumstance, I'm not going to contend that you can. In a partnership context, the position may be different. So this is either parties contracting to this effect, or it may well be recognition of what is capable of being partnership law in Cayman anyway.
Is there a difference between a fiduciary responsibility for safekeeping, which I think was the wording of clause 18.4, fiduciary responsibility for safekeeping funds and assets, and the wording of the statute, which was, I think,
Fiduciary or representative capacity.
no, receipt of profits, was it? That's what I was thinking.
It's profits accruing to it in a fiduciary or representative capacity.
Yes. So what the deed is dealing with is safekeeping of funds. So you have to look after the things, the money and the other assets which you have under your control as general partner.
Yes.
And it's not obvious to me that that's the same as asking the question posed by the statute as to whether profits accrue to you in a fiduciary capacity. Your submission is that they mean the same thing?
Lord, no. I accept the point I anticipate your Lordship is making to me, that good housekeeping of assets by a fiduciary doesn't necessarily answer the Section 8(2) statute question.
No.
And if I didn't have the benefit of the first tier's conclusions here, let's just assume they didn't make any relevant findings, and I only had clause 18.4, that gets me some of the way home, but doesn't necessarily get me all of the way home. Because there would then be a debate as to whether if you hold the cash as a fiduciary, is that the same as the profits accruing to you in a fiduciary capacity?
Well, an agreement to look after cash doesn't answer the question as to whose cash it is. As you said a little while ago, trustees are fiduciaries. Indeed, they're the sort of paradigm example of fiduciaries, if you're a bare trustee, you receive the money in a fiduciary, it accrues to you in a fiduciary capacity. There's a relevant doubt about that. And you also have to look after it. But you could have a situation in which A agrees with B as a matter of contract. I'll receive these funds. I'll look after them to a fiduciary standard in the same way as a fiduciary would. But nevertheless, they're not B's monies in any real sense. And they remain A's monies, though A has a contractual obligation to deal with them in particular ways.
I accept that.
So the two are not coterminous, these two concepts.
And I accept that. And if I didn't have the benefit of what the first tier found, there would be an open debate. If all I could point to was 18.4, there'd be an open debate as to how far it gets. The point of showing you 18.4 was to make clear that under the deed, the holding of the cash is as a fiduciary. But I do have the benefit of what the first tier found as a matter of Cayman law about the entitlement of Cayman Limited to the profits, i.e. it has no entitlement where those profits are, under the deed, to be allocated to the island.
Can I ask another rather simple question? You referred us to this deed in volume supplementary bundle B.
And it is the same.
It's the same one as we were looking at.
It was, and I'm afraid I gave you the wrong reference. But
Why have we got it twice?
There was a debate between the parties when we put the core bundle and supplementary A together, whether we should repeat in B anything that was in A. I was rather in favour of not repeating, but for whatever reason they are repeated.
Thank you. So we can just ignore what's in that tab of B, can we? We don't need it. It's a complete reproduction of what's in A.
Exactly. And there are some things that have been repeated. There are some things that are in B and A.
But is there anything that's in A and not in B?
No.
Okay.
I think that's right. So I'm conscious we've wasted some trees now. But relevantly, we say, given that the entitlement to profits in Cayman LP is governed by the Cayman LP deed, and that is governed by Cayman law, I do not need to go beyond paragraphs 135 and 136 of the first tier to establish that what Cayman Limited gets under the UK LPD as GP in the Cayman LP is a profit that accrues to it in a fiduciary capacity. Now, what my learned friend Skeleton then goes on to do is to give you some analysis resting on some old UK partnership cases to elucidate the debate about whether a partner is a fiduciary either as regards his or her fellow partners or at least as regards an amount that is received by a given partner as he or she hold it as a fiduciary for the other partners.
Your point is it doesn't really matter what English law is, since Cayman Limited's entitlement is governed by Cayman law. The question of foreign law is one of fact. The FTT has made its findings of fact based on the expert evidence, and that expert evidence, whether it's right or wrong, doesn't matter. Whether it conforms with English law doesn't matter. There are findings of fact which are unchallengeable in this court.
And unchallenged. Yes. Now, there is...
So you can't, HMRC cannot, you say, so to speak, confess and avoid by resorting to English legal principles.
Correct. Now, so you see where the debate may take, my learned friend. There is a decision in the High Court in a case called Piddock and Burt in 1894.
Yeah.
Very short decision delivered extempore about the Debtors Act. And the question there was whether a sum received by one partner was held as a fiduciary for the other, and whether the holding and receiving partner was exposed to a writ of attachment under the Debtors Act 1869. Held extempore, no, he's not a fiduciary. I have submissions which I'll deliver at some stage if need be, to the effect that that decision is either distinguishable on the basis that it is concerned with the provision of the Debtors Act and doesn't state a general principle of partnership law, or if need be, I'm going to say it's wrongly decided. But none of this is necessary because that is a debate about English partnership law, whereas your Lordship has observed we have the answer as a matter of Cayman law.
But I mean, if an English trading partnership receives payment from a client, one of the partners receives payment from the client for work done, you would say that that partner receives a fee from the client in a fiduciary capacity, would you?
Yes, because there's an obligation to account in accordance with the partnership deed that reflects the relationship between the partners.
So all money received by all partners for the work which they carry out as a trading partnership is received in a fiduciary capacity.
Yes. Now, Piddock and Burt says I'm wrong about that. And so there is a debate that might have to be had in this court, whether in this appeal or later, as to whether that's right. And that is perhaps suitably badged as a hard question of partnership law. But this court does not have to answer that here because we don't get to English law. So issue 1B, ultimately, we say, is very simple. The Upper Tribunal misread the statute in the way we set out in our skeleton argument. My learned friend's subsidiary arguments on this his only response is to say Cayman Limited does not receive in a fiduciary capacity. That is not a contention that is open to him in light of the findings made by the first tier. Standing back, if that's right, putting issue 2 aside for a moment, this court arrives at the conclusion that the entity to which the profits are actually allocated under the partnership deed, BILED, is taxable on those profits. And that should, we say, be a comfortable conclusion. It gives effect to the clear purpose of Section 8 of the 1988 Act.
This issue is addressed by us on the assumption we've lost on issue 1A.
1A, yes.
So Philod is not a partner of Cayman LP.
It's not a partner of UKLP.
UKLP. Sorry, UKLP. The transparency principle allows the revenue, requires the revenue to look through UKLP to its partners and tax them.
Yes.
Can it tax Philod, who's not a partner?
Putting aside for a moment the complexity of it being a Cayman partnership, if one had a chain of English general partnerships, and I'm putting aside a debate about a sub-partnership for a moment, the transparency that is required by the tax code would allow you to look up through each partnership until you find the partner that is entitled to the profits.
Even though they're not a partner of the one that you start with.
Yes, because if I'm wrong about my issue 1A contentions, you don't look at the bottom and look at the top. You look at each of the stages, but what you do is you apply the transparency principle to each partnership at each stage, and you keep looking up following the appropriate partnership share until you arrive at an individual or corporate partner. And you tax that individual to income tax or corporate to corporation tax. And if the consequence of 100 at the bottom is an entitlement to 17 at the top in the hands of Company A, you tax Company A on 17.
And it doesn't require a filer to have a permanent establishment in the UK or to be a UK resident company or anything like that?
Because the underlying business is an investment management business carried on in the UK, FILED is treated as having a permanent establishment in the UK.
Does it matter if the underlying business is carried on by the LLP which moves to Guernsey? Does that matter?
The shift between LP and LLP when the LLP was in the UK makes no difference. Once the business is carried on in Guernsey, then FILED or the partners upstream have an entitlement to profits of a business that's not carried on in the UK.
So it ceases to be taxable, is that right?
Well,
Because we
FILED
got into this debate because you said there should be a comfortable conclusion.
Yeah.
And I'm just testing how easy it is to say it's FILED that ends up bearing the tax.
As it happens, FILED's UK resident.
Oh, right, okay.
So that issue doesn't arise. But if you had Switzerland Co, that was one of the parties, where the business is carried on in London, Switzerland Co is taxable in the UK. Once the business is carried on in New York or Guernsey or Tokyo, Switzerland Co wouldn't be taxed in the UK.
Thank you.
So we say properly understood, issue 1B is a simple issue. And if I'm right about 1B, then I've got to turn to 2. But the other route to that conclusion is issue 1A, which, as I badged in opening, is a harder question of partnership law. So we put our case on 1A in 2 ways. Firstly, we say, as a matter of law, once a partnership, here Cayman LP, that itself doesn't have separate legal personality, is admitted as a partner in another partnership, here UK LP or later the LLP, then the partners in the former, call that top partnership, become partners in the latter, call that bottom partnership. We say that arises as a matter of legal principle.
Is that a legal principle which is a rule applicable to partnerships, or is it a part of a legal rule which is applicable to contracts purported to have been made by unincorporated associations without legal personality?
In my submission, it's the former.
Special to partnerships. Why should there be such a rule, special to partnerships?
Can I come and deal with that in a moment?
Right.
Just so the court still sees where I'm going. The second way in which we put the case on 1A is to say, well, even if that doesn't arise as a matter of law, a matter of legal principle, such that the focus has to be on the relevant documents by which the top partnership becomes a partner in the bottom partnership, then we say that is what happened here in the present case, and the Upper Tribunal were wrong to conclude otherwise. Now, the basic facts relevant to issue 1A are not in dispute. So RBS became a partner in Cayman LP. this is thinking of matters chronologically. So RBS was a partner in Cayman LP. Cayman LP was set up to carry on the business of investing in an investment management business through being a limited partner in UK LP. That's clause 6.1 of the Cayman LPD. It was set up to be a partner in UK LP. The UK LP deed provides for all of the partners in that deed to come together in partnership with each other, including Cayman LP, which was defined as the special limited partner. We know that Cayman LP has no separate legal personality in Cayman law, and we know that Cayman Limited was initially a partner in UK LP, but that it then resigned.
And at the time when the UK LP deed was made, RBS was already a partner in Cayman LP, is that right?
These events all happened on the same day. I don't think there's going to be a debate as to in what order these steps happened, but they all happened on the same day. And that UK LP deed provides for a share of profits to be allocated to, quotes, Cayman LP. And we know that any profits allocated by UK LP to Cayman LP were then allocated under the Cayman deed to its partners, one of which was, in the events that turned out, Filet. And what Filet got was a share of profits from Cayman LP that were derived from super profits made by UK LP. So pausing there, is there a general rule of partnership law, or one found in the Limited Partnership 1907, or indeed in the later Limited Liability Partnership Act of 2000, to the effect that a member of the top partnership, which itself becomes a partner in the bottom partnership, does not thereby become a member of the bottom partnership? And for our part, we can find no such general rule. Indeed, we say the reverse is true, at least where the top partnership doesn't have separate legal personality. Now, there is one authority that gets close to addressing this question. It's a decision of Mr. Justice Park in the High Court in Mater and Brodie. So can we invite you to turn that up? It's the second volume of authorities. Tab 40, beginning at page 353. Volume 2, tab 40, page 353, it concerns Mr. and Mrs. Brodie, who were seeking tax relief on interest in respect of sums they borrowed to advance to a partnership. And this debate related to land in Scotland and farming businesses in Scotland. So, in simple terms, Mr. and Mrs. Brodie borrowed money and advanced the capital to a Scottish partnership called Skeldon Estates. And Skeldon Estates then itself went into partnership with a Mr. Murdoch in the second or lower partnership of W. Murdoch and Sons. And some of the capital that had been borrowed and put into Skeldon Estates was advanced into Murdoch to carry on the farming trade.
Well, yes and no. If you look at paragraph 4D of Mr. Justice Park's judgment, page 507 of the report 369 of the bundle, he describes the second partnership. There were stated to be two partners. The second party was Mr. Henry Murdoch. The first party was Whipple. It was stated to be Mr. and Mrs. Brodie. They were stated to be partners. It wasn't just the Skeldon Estates partnership. They were named.
But the contract partnership was actually set out in the Special Commissioner's decision on page 357.
Yes, 357 letter C. Maybe the court has already got this, but the tax question was, could they get interest relief on the monies they borrowed? And the revenue said, well, you borrowed to put money into Skeldon Estates, but the trade was carried on by Murdoch. So you've got a mismatch between where the capital was advanced to a partnership and where the trade was carried on. They're two different partnerships. And the Special Commissioner said, no, relief's available. And the judge agreed. And in part, the judge had to address the position of partnerships in Scotland. So his Lordship's judgment begins at 367, Henderson acting for the revenue. His Lordship sets out the relevant question as to interest relief on 368 between letters A and C. And then the legal issue is summarised on page 370 under the heading just below letter G. These are the statutory provisions. And then over the page at 371 of the bundle, letter A, the Crown's principal argument, I'll paraphrase, but what Mr. Henderson said was you contributed to Partnership 1, but the monies were used for the trade of Partnership 2. And the judge says at letter C, no, in my judgment, this ignores the true legal nature of a partnership and the relationship of a partnership and its members. And then leaving aside Scottish partnerships, a trade carried on by a partnership is a trade carried on by its members and by each of them. And what his Lordship says at E, Mr. Henderson says the money has been used wholly for the purpose of the trade carried on by W. Murdoch and Son. He's correct as far as he goes, but it doesn't deal with the proposition that the money is thereby used wholly for the purpose of the trade carried on by the partners in W. Murdoch and Sons. Those partners are Skeldon Estates Partnership and Mr. Henry Murdoch. And his Lordship, between letters F and G, he puts it two ways, each correct, saying the same thing. Skeldon Estates Partnership carries on the trade of farming as a member of a firm called W. Murdoch and Son. W. Murdoch and Son, a firm of which a member is Skeldon Estates Partnership, carries on the trade of farming. His Lordship said, well, both of those are right, and therefore the conditions in 362(1)(b) are satisfied. The money is advanced to Skeldon Estates is used for a trade that it carries on as a partner in W. Murdoch. And then turning over to page 372 of the bundle between letters B and C, before the Special Commissioners, a large element of the Crown's case rested on the special feature of a Scottish partnership whereby it has legal personality. He says the argument, if I have it correctly, was the trade of farming carried on by W. Murdoch and Son was not also carried on by the members of W. Murdoch and Son, as W. Murdoch and Son was a separate legal person. And then both sides gave evidence of Scottish law, and the Special Commissioner preferred the evidence of Mr. Murray QC, who gave evidence for Mr. and Mrs. Brodie. And the judge says Professor Murray's critical proposition appears to me that although Section 4.2 ascribes separate legal personality to a Scottish partnership, it remains the case that by virtue of Sections 1 and 4, there are still persons carrying on business in common with a view to profit. And then he identifies a different point that has arisen between letters E and F. What Mr. Henderson was saying was that separate legal personality of Skeldon Estates made it easy to see the farming trade was carried on by the partnership to which Mr. and Mrs. Brodie contributed the money. That was Skeldon Estates. But because it was a legal person, it could itself be a partner in W. Murdoch and Son. Mr. Henderson said, well, the position would have been different in England. So he's there, the contention for the Crown was there's a difference between Scotland and England. And what Mr. Henderson was urging upon the judge was, well, you shouldn't identify a result that is different between the two, and you should make one conform to the other. And the judge rejects that between letters G and H. In the first place, I tend to the view that the tax result will be the same with an English partnership. Suppose that A and B were the partners in Partnership X, an English partnership. Suppose further there's an agreement was entered into between Partnership X and C to form another partnership, Partnership Y. It was submitted that the analysis under English law would be that Partnership Y had 3 members, A, B and C, not 2. I am willing to assume that is right. So His Lordship is there saying that the partners in top partnership, or Partnership X, become partners in the bottom partnership, Partnership Y, alongside C, once Partnership X becomes a partner in Partnership Y. So let me then accept at this stage what is obvious. His Lordship is saying he assumes it to be right. He doesn't put it any higher than that. Decision of the High Court, obviously not binding on this court. But His Lordship there arrives at a conclusion for the purpose of dealing with one of the arguments advanced by the commissioners that would justify a conclusion in this case that the partners in Cayman LP become partners in UK LP when the partners in UK LP admitted, quote, Cayman LP as the partner in UK. That conclusion is consistent with what the judge was prepared to assume was right later in.
Why? Well, what's the justification for the assumption?
Because the effect in law of the admission in the bottom partnership of an entity that itself does not have separate legal personality is, we say, should as a matter of principle be, to admit into the bottom partnership the partners of the top partnership. Because that is what the partners of the bottom partnership have agreed in entering into the deed that admits the top partner as a partner in the partnership. Top partnership.
Is your submission as simple as this, that when we read the words Cayman LP in the deed, that does not mean a person, because there is no such legal person. So you read it as if it said A, B and C, the partners in Cayman LP.
Yes.
That's your case.
That's it. It's the first way. I've got a different way of putting it in a moment. That's the first way we put it.
So that's a question of construction of the deed.
The first way I put it is that it's a matter of legal principle.
Reference to a partnership under a system of law like Cayman or England, but not like Scotland, which does not recognise the partnership as a separate legal entity, is, as a matter of law, reference to all its constituent partners. And that is so whether it's a limited partnership or an 1894 Act partnership.
Yes. And the only fact you need to justify that conclusion is the admission of, quotes, Cayman LP into UK LP.
What happens if the identity of the partnership changes? Do the new partners in the firm automatically become partners in what you call the bottom firm?
Yes. So the admission of the partners from time to time, because you have admitted into bottom partnership the partners of top partnership by admitting, quotes, here, Cayman LP.
That, I mean, my recollection is, although it's a long time since I looked at it, that when banking businesses were carried on by partnerships, firms, in the 19th century, there were rafts of cases in Lindley saying that when you bank with A and B, which is a firm, and A and B admit a new partner C, you have no contract with C until you novate it, which you quite easily do, but you have to novate the contract to become in contractual relations with C. So simply by entering a contract with a firm, you're not entering it with the partners for the firm for the time being, but with the partners in the firm when you enter into it. Am I wrong about that?
Well, we can't find any, I'm going to show you two bits in Lindley in a minute, but we can't find any authority, we can't find any authority either way, apart from what's in Major and Brodie. There's a couple of other clues I'll show you in a moment. We can't find any case law on the 1890 Act, or indeed on the 1907 Act, that addresses this, yea or nay.
Okay.
The closest we can find is what Mr. Justice Park was prepared to assume in dealing with an argument. And I accept it is he was prepared to assume.
Yeah, and you say this is a rule specifically applicable to partnerships.
Yes, I'm not
Because if it, I mean, in the case of an unincorporated association which purports to make a contract, having no legal personality, it's quite often said to be the managing committee. You say that's not the case for the partnership.
And I'm not seeking to advance any wider general principle that would deal with matters of contract. Now, there are two bits of Lindley. This is volume 3 of the authorities. Tab 69. Page 1014 of the bond. And this is the 20th edition, which is 2017, paragraph 427. Since
not the
under
current
English
edition.
Well, hold on, sorry.
Not the current edition.
I'm coming to that in a second. Paragraph 427, since under English law a firm does not have separate legal personality, it cannot as such be a member of another firm. Thus, where a firm purports to become a partner, this will, as a matter of law, constitute each of the members of that firm as a partner in his own right. And then the footnote is, assumed to be correct in Major and Brodie, not even adverted to. There's a case called James Hay Pension Trustees, where the issue could have arisen but wasn't addressed. And the author of this edition of Lindley and Banks finds support for this in the partnership account regulations. Just for your note, they're in volume 1 at tab 12. Those are particular requirements imposed on partnerships to have in effect audited accounts. And those partnership regulations deal with circumstances in which one partnership is a partner in another partnership. And it ensures that the accounting obligation applies to all of the partners in the bottom partnership on the assumption that the partners in the top partnership become partners in the bottom partnership. the regulations assume my proposition is right, but of course I accept they don't prove that it's right. So that's why Lindley refers to the partnership regulations. So reading that, that is consistent with our view of the world. If you look behind tab 73, you get the 21st edition, which is 2022, and page 1036. The paragraph is now 442. And this time, a sentence in effect is added to paragraph 442 comparing the two. The position will be otherwise if on a true analysis only one of the partners in the firm is intended to become a partner in the second firm. And footnote 139 is to the Upper Tribunal's decision in this case. So what was in the 2017 edition is now qualified by the decision that we're appealing against.
It's difficult to see how the two can be squared.
There is a way that the two can be squared, which is if the decision of the Upper Tribunal is a decision that doesn't address the general principle, but proceeds on the basis that what you have to decide is whether the partners in fact agreed that this should be true. The other way I put this is to say, well, what the Upper Tribunal said is, well, Mr. Gammy's proposition at the time, but Mr. Gammy's proposition might be right, but it's not necessarily right. You've got to see what the partners actually agreed. And they decided the partners hadn't agreed that the partners in Cayman would become partners in UK. I'm going to say in a moment that's wrong.
On the fact.
On the facts, on the agreements. But that's the way you would square these two bits of Lindley. If the Upper Tribunal's decision is respecting the general principle but not regarding it as absolute.
But your first proposition, I thought, was it is absolute.
That's my first proposition. So that
Your proposition is that the sentence you read us from the current edition is simply wrong.
Yes. Yes, the additional sentence between the two editions is wrong. So we say, as a matter of principle, Philed became a partner in UK LP. Pause there just for 1 second and ask, well, why are we doing this exercise? In a world where, for UK tax purposes, you look through partnerships because they're transparent, and you tax the partners by reference to their share of the profits of the underlying activity, and the revenue accept that's the right way to treat UK LP, why would you then not adopt the same approach as regards Cayman LP? And if that means concluding that Philed is to be taxed as a partner of UK LP, so be it. There's nothing contrary to purpose or policy in arriving at that conclusion. You're just saying the profits of UK LP are ultimately enjoyed by a number of people, one of whom is Philed.
That's a different point. I mean, your point here is about partnership law. Nothing to do with tax.
Well, the point I was making is that the conclusion I'm inviting you to arrive at is consistent with the way that the UK tax system treats partnerships.
Yes.
Can I be sure I've understood how far this submission goes? The deed you rely on, under which Cayman LP became a partner of UK LP, is the deed of 6th of August 2007, which you showed us in supplementary bundle A.
6th of July.
6th of July 2007. At that stage, Philed wasn't any party to this structure and only became an assignee of the interest in
RBS is interested in 2008.
in 2008. So your submission is, it didn't then sign a new deed of adherence in UKLP.
No, that's a point that's made against us, and we accept that.
So your submission is that when we look at the 6th of July 2007 limited partnership deed, and it says that the 54th partner is Cayman LP, that does not just mean the partners in Cayman LP on the date on which it's signed, it means the current and future partners of Cayman LP from time to time, whoever they may be. As I say, I find that quite... Leave aside your general proposition. When you read Cayman LP in this deed of July 2007, you read it as if it said A, B and C, who are the current partners. I find it a surprising proposition, not one that I would readily accept, as a matter of contract, that this contract was made not only with the then partners, with whoever subsequently, in separate transactions to which none of these 53 people are parties, acquires an interest in Cayman LP. Because, as I say, I thought Lindley was full of cases about how partners in ordinary 1890 Act partnerships become liable on contracts which they weren't party to when the contracts were entered into, and the answer is through novation. But unless you novate it, they don't become parties. But is there a difference between a partnership deed and another contract?
Can I turn
I
off?
mean, I've noticed the time, but I'm sorry. I just
Well, I see your lordship's point. The first way I put issue 1A is it's just a matter of general principle, and it's partners from time to time. The second way, which your lordship is perhaps edging towards, is to say, well, that if that may or may not be right, we've actually got to look at what the partners actually agreed in these deeds. Does my proposition still hold true? I'm going to say yes, but I need to explain why. That might be a convenient moment.
Yes. All right, thank you very much. 2 o'clock.
Mr. Peacock, I have now sorted out the laptop. Thank you very much.